If multiple checks are issued under a single agreement and all of them bounce, can you file a separate case for each check? Or does the law allow just one criminal case for the entire transaction? The Supreme Court of India has now provided a clear, authoritative, and final answer. Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. In this video, we will analyze a very important and recent judgment that resolves a long-standing confusion in check bounce law and clarifies the rights of creditors under Section 138 of the NE Act. Case title: Sumit Bansal vs. MSMGI Developers and Promoters and Another. Court: Supreme Court of India, New Delhi. Bench: Honorable Justice Sanjay Karol and Honorable Justice Prashant Kumar Mishra. Date of judgment: 8th January 2026. Neutral citation: 2026 INSC 40. Background of the case. In 2016, Shri Sumit Bansal entered into an agreement to sell with MSMGI Developers and Promoters. The agreement related to the purchase of 3 commercial units in a project named MGI Mansion, situated at Ghaziabad, Uttar Pradesh. Financial terms of the agreement. Total sale consideration: 1,72,21,200 rupees. Additional appreciation amount: 35 lakhs rupees. Crucial contractual condition. The agreement specifically provided that the sale deeds must be executed and registered on or before 30th September 2018. In case of failure, the developer was bound to refund the entire amount and pay the agreed appreciation amount. To secure this obligation, Shri Manoj Goyal executed a personal guarantee on 27 July 2018. He assured repayment through personal checks, apart from checks issued by the firm. Issuance and dishonour of checks. Since the sale deeds were not executed within the stipulated time, the respondents issued a total of 4 checks on the same date. Breakup of checks. Out of these 4 checks, 2 checks were issued from the firm's account towards payment of the principal amount and the appreciation amount. The remaining 2 checks were issued from the personal account of the proprietor towards the personal guarantee obligation. Dishonour of checks. The personal checks were presented on 5th December 2018 but were dishonoured on 6th December 2018, and the reason for dishonour was stated as exceeds arrangement. On the other hand, the firm's checks were presented on 15th December 2018 but were dishonoured due to insufficiency of funds in the account. Statutory compliance under Section 138. The statutory notices were issued within the prescribed limitation period and were duly served, but no payment was made within the statutory period. Accordingly, the complainant filed separate criminal complaints in respect of each dishonoured check. Proceedings before the Delhi High Court. The respondents approached the High Court under Section 482 of the CrPC seeking quashing of the complaints. The High Court refused to quash complaint number 2823 of 2019 relating to the personal checks, while complaint number 3298 of 2019 relating to the firm's checks was quashed. Further, complaint numbers 13508 of 2019 and 743 of 2020 were also not quashed. The High Court observed that 2 complaints for the same liability would amount to parallel prosecution. Aggrieved by this decision, both parties approached the Supreme Court. Issues framed by the Supreme Court. The Supreme Court examined: 1. Whether multiple dishonoured checks from one transaction create separate causes of action under Section 138. 2. Whether the High Court was justified in quashing a complaint under Section 482 CrPC. 3. Whether disputed facts can be examined at the quashing stage. Arguments of the parties' complainants' main arguments. Each dishonoured check satisfied all ingredients of Section 138. Every check created a distinct offence. Dishonour was not disputed. High Court wrongly conducted a mini-trial respondents' main arguments. All checks related to one liability. Filing multiple complaints amounted to double prosecution. Alleged absence of subsisting liability or excess repayment. Key observations of the Supreme Court. 1. Each dishonoured cheque creates a separate offence. The Supreme Court categorically held that each dishonoured cheque, once the statutory requirements under Section 138 are fulfilled, gives rise to an independent and distinct cause of action. Even if multiple cheques arise from the same transaction or agreement, the dishonour of each cheque constitutes a separate offence under law. 2. High courts cannot conduct a mini-trial under Section 482 CrPC. The court strongly reiterated that while exercising inherent powers under Section 482 CrPC, high courts cannot examine disputed questions of fact. Issues such as whether the cheque was a security cheque, whether liability existed, or whether payments were already made, are matters of evidence and must be decided only during trial. 3. Narrow and cautious use of quashing powers. The Supreme Court emphasized that the power to quash criminal proceedings must be exercised sparingly and with great caution. Quashing is permissible only when the complaint, on its face, does not disclose any offence. If the basic ingredients of Section 138 are present, the complaint must proceed to trial. 4. Presumption under Section 139 Act is mandatory. The court reaffirmed that once issuance and dishonour of cheque are admitted, Section 139 creates a statutory presumption of legally enforceable debt or liability. This presumption can be rebutted only by leading evidence, not by mere arguments at the quashing stage. Final judgment. After considering the entire factual background, statutory framework, and settled principles of law, the Supreme Court allowed the appeal filed by the complainant, Shri Sumit Bansal. The court set aside the order of the Delhi High Court quashing complaint case number 3298 of 2019 and restored the said complaint to its original position, directing that it shall proceed in accordance with law before the trial court. At the same time, the Supreme Court dismissed all the appeals filed by the respondents accused, thereby upholding the High Court's refusal to quash the remaining complaints arising out of the dishonoured cheques. The court made it expressly clear that all questions of fact, defences of the accused, and issues relating to liability or repayment are kept open and shall be adjudicated independently by the trial court on the basis of evidence, without being influenced by any observations made by the High Court or the Supreme Court at the preliminary stage. Future impact of the judgment. This judgment will have far-reaching consequences for cheque bounce litigation across the country. The Supreme Court has now clearly settled the law that multiple dishonoured cheques give rise to multiple independent offences under Section 138 of the Negotiable Instruments Act, even if they arise from a single transaction. As a result, the scope for pretrial quashing of cheque bounce cases under Section 482 CrPC has been significantly narrowed, and high courts are now expected to exercise extreme caution before interfering at the threshold. The ruling also strengthens the legal remedies available to creditors, enabling them to pursue separate proceedings for each dishonoured cheque without fear of allegations of parallel prosecution. Most importantly, the judgment reaffirms the core object of the Negotiable Instruments Act, which is to ensure financial discipline, credibility of commercial transactions, and confidence in cheque-based payments in the Indian economy. Conclusion. This judgment is a landmark clarification in cheque bounce jurisprudence. It strengthens commercial confidence and ensures accountability in financial transactions. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.